Hi, I'm Alex McGlade, a trainee solicitor here at CG Professional. Some of the most hotly and heavily negotiated clauses in any commercial contract are the exclusions and limitations on a party's contractual liability to the other. It follows that this is one of the areas which regularly finds its way into court proceedings, and in one such recent case, the High Court has found that an exclusion of liability clause in a supplier's standard terms and conditions was ineffective as it failed the reasonableness requirement in the Unfair Contract Terms Act 1977, commonly known as UCTA. The UCTA reasonableness test applies in relation to exclusion and limitation of liability clauses where a party is dealing with another on its standard terms and conditions and tries to exclude liability for things like negligence, breach of contract and non-fraudulent misrepresentation. If an exclusion fails the UCTA reasonableness test, it will be wholly ineffective, and if the exclusion is contained in a limitation of liability clause, it may cause the whole clause to fail. The relevant test is whether it was fair and reasonable to include the term in the contract, considering everything the parties knew or should have reasonably contemplated when they made the contract. Reasonableness is assessed at the time the contract was made, and the term must be reasonable in every application that is realistically foreseeable, not just the most likely or common situations. The case which recently found its way into the High Court was the case of Phoenix Interior Design Limited and Henley Homes plc. In this case, it was found that the relevant clause was buried in the standard terms and the supplier had failed to bring it to the customer's attention. The clause in question stated that the seller shall be under no liability under the above warranty or any warranty, condition or guarantee if the total price of the goods had not been paid by the due date for payment. On the facts, the judge found the exclusion was ineffective because it was an unusual clause tucked away in the undergrowth of the terms and conditions, which was not highlighted to the customer. The judge also ruled that the impact of the clause was exorbitant, as the consequences of a slight delay or deduction would bar all rights of redress against the supplier, and there was a lack of clarity over what the due date meant. There was also a dispute in this case over whether the terms and conditions, which contained the exclusion clause in question, were properly incorporated into the contract. On the facts, the judge found that they were expressly incorporated, even though they could not be found overleaf as had been suggested in some of the pre-contract proposal documents. The terms were, instead, supplied separately to the customer, both in hard copy and by way of email. However, this argument on incorporation could not have helped the supplier's case on reasonableness, and the fact the terms and conditions were not provided overleaf did encourage the customer to challenge their incorporation. Although this decision does not create new law and is specific to the case, it does highlight certain practical points to consider when drafting and dealing with limitation clauses in standard terms. Firstly, ensure that harsh and unusual exclusions and limitations are visible and well signposted, and avoid hiding them in the small print. The same factors affecting the incorporation of standard terms are relevant to the UCTA reasonableness test. A supplier is therefore likely to have a stronger case on reasonableness if exclusion or limitation clauses are transparent and easy to spot. Secondly, contracting parties should make it as easy as possible for the counterparty to find the standard terms. Given the impact of getting this wrong and not being able to rely on any limitations or exclusions included, it is worth making sure that these types of clauses are properly incorporated. Please get in touch if you need any assistance with the preparation or review of any of your standard terms and conditions.